Welcome once again to Lehto's Law. Here's Steve Lehto.
We've had a lot of updates lately. I do a story and a couple days later something breaks. Sometimes it's a week or two, but here's a big one. I did a story not so long ago about how the Federal Trade Commission had issued a new rule saying businesses couldn't use non-competes the way they had in the past. And that rule was narrowly passed by the Federal Trade Commission. And a lot of people said, well, gee, is that going to withstand judicial scrutiny? Will it survive a court? And the answer is apparently not. Federal judge throws out U.S. ban on non-competes. The story just happened recently. National Public Radio is who I got this story from. Andrea Hsu wrote it. A federal court in Texas has tossed the ban on non-competes that the Federal Trade Commission had said would take effect September 4th. In the ruling, the judge for the U.S. District Court for the Northern District of Texas wrote that the federal agency had overstepped its power when it approved the ban. Federal Trade Commission lacks substantive rulemaking authority with respect to unfair methods of competition, she wrote. The role of an administrative agency is to do as told by Congress, not to do what the agency thinks it should do. And there have been some other recent rulings from our Supreme Court suggesting that some of these agencies need to dial it back a little bit. So we'll see what happens if this goes up on appeal or not. A tax service firm in Dallas had filed the suit to block the rule just hours after the FTC passed it, and it would have banned non-competes for almost all U.S. workers. That was passed back in April. Now, the lawsuit was joined by several organizations that represent a broad swath of American businesses, including the U.S. Chamber of Commerce, the Business Roundtable, and the Texas Association of Business. An estimated 30 million people, or 1 in 5 American workers, are bound by non-competes. The employment agreements typically prevent workers from joining competing businesses or launching ones of their own. And so here's the thing. I've mentioned before, and just to be clear, there's several different types of non-compete agreements. So if I go to sell you my business, it makes sense that I would sign something saying I will not compete with you after I just sold you my business. So that one makes sense. It's part of the goodwill of the sale, right? However, if you go to work someplace and they say, here, before we hire you, you got to sign this non-compete. Well, the question is, are they doing that because they're about to give you a bunch of trade secrets and client lists? Or is it because they simply want to lock you up so you can't go find a better job? And that's one of the criticisms that people have is it makes sense at the higher levels, people who have, the keys to the kingdom, that they would sign a non-compete. But entry-level workers, that's the bigger question. We'll talk about that in just a second. So the FTC says it's disappointed, but will keep fighting to stop non-competes. Now the question is, does that mean they're going to appeal this or address it some other way? We are seriously considering a potential appeal, and today's decision does not prevent the FTC from addressing non-competes through case-by-case enforcement actions, wrote an FTC spokesperson. In requesting relief, the tax services firm had argued that the ban on non-competes would inflict serious and irreparable injuries on its business, including by putting its confidential information at risk and enabling its competitors to poach valuable employees whose knowledge and training would go out the door. That's another term you'll hear thrown around a lot here, and that is when employees get poached. So I'm starting a business. I'm kind of trying to get things going, and there's another business I want to compete with, and I can't hire the owners, but I can hire some people who work for the owners. Come on over here. Bring your expertise. So the judge's ruling preserves the economic freedom of businesses and their employees to enter into non-compete agreements, said the firm's general counsel. They play a vital role in safeguarding intellectual property and innovation, building trust within businesses, and investing in training their people. The FTC has long argued that non-competes hurt workers. The freedom to change jobs is a core economic liberty and to a competitive, thriving economy, said the chair of the FTC in a statement when they first talked about this. Non-competes block workers from freely switching jobs, depriving them of higher wages and better working conditions, and depriving businesses of a talent pool that they need to build and expand. According to the Federal Trade Commission, the new rule would have led to wage increases totaling nearly $300 billion per year and the creation of 8,500 new businesses per year once workers could freely pursue new opportunities without the fear of being taken to court by their current employers or past employers if they left. And of course, where those numbers come from, I will admit, I don't know how they conjure these things up. The ban would carve out an exception for senior executives with existing non-compete agreements on the grounds that these agreements are more likely to have been negotiated The FTC estimates that less than 1% of the workers would qualify as senior executives. Existing non-compete agreements would not need to be formally rescinded under the rule if it still stood, but employers would have been required to inform their employees that they are no longer enforceable. So keep in mind several different kinds of non-competes we're talking about, and the primary ones that completely make sense to me are the ones where if I sell you my business as part of the goodwill, I agree not to compete with you for a while. Number two, if it's a negotiated thing where you're trying to bring somebody aboard and you know they're going to be exposed to client lists, supplier lists, other proprietary information, proprietary formulas, proprietary processes, things like that, to do their job, you got to give them all this inside information. It makes sense to me that you tell them when you hire them, look, we're going to do this for you. We might even train you, but we don't want to train you and give you all this information just so you can go work for a competitor. That makes sense to me, but that's a negotiated one. But when somebody walks in the front door and says, hey, I saw a help wanted sign, they say, great, you're hired, but sign this. That's a little different to me. And I made the comment about fast food workers. And I got a really, really angry comment from somebody who goes, Steve, you're just fear-mongering. You're just fear-mongering. There is no such thing as a non-compete agreement in the fast food industry except at the highest levels. And, you know, when people say things like that, maybe Google something for once. Google is your friend. So I actually Googled the phrase fast food workers and non-compete agreements. I think that's what I've Googled. And among other things, I found a statement here. It says that researchers estimate that 1 in 6 U.S. food preparation and service workers have signed a non-compete agreement, as have 1 in 5 workers in the agriculture or hunting industry, based on a survey of nearly 67,000 workers. Now, you could say, Steve, wait a second. You just found a sentence on the internet and you believe it? Oh, well, no, it says according to a survey. And so you can go look the survey up. But by the way, when you do the search I talked about, you're going to get hit after hit after hit after hit. Now, you will find out that there have been some gross overstatements where people will say things like, every McDonald's worker in America has signed one. And McDonald's will say, no, they haven't. And it depends on the company and what they do. But the paper, the survey, where they actually surveyed 67,000 workers and then extrapolated out those numbers, you can read it if you want. It's 58 pages long. It's entitled Employment Restrictions on Resource Transferability and Value Appropriation from Employees. I'm not sure what your plans are for the rest of the afternoon, but if you want to, you can spend it reading that. The point is that I'm not making this stuff up. The only question is, how fair is it? And if it's fair or not fair, really doesn't answer the real problem, and that is, should it be legal or not to ask an entry-level employee who's not going to get proprietary information, who's not going to get the keys to the kingdom, who's going to literally be troweling proteins sort of into a shell and saying, thank you, come again. Does that person really need to sign a non-compete? I mean, are they going to steal the pictograph that describes how to trowel the protein-like substance? I'm not making that up. Read Fast Food Nation. If you can do it in a pictograph, it means you can hire a different class of employee. And so the point is that, and again, I'm not making fun of anybody who works in the industry. I'm simply pointing out that I don't think that, you know, like I spent a couple of years pumping gas. I pumped gas at a gas station in the old days in Michigan where there were no self-serve stations near where I lived. You pulled in, I'd run out, hi, how can I help you? You need $5 worth of gas. I'll pump the gas for you, thank you very much. That if they'd asked me to sign a non-compete or said you couldn't work here, I might have signed it. But what did I learn from them that I wouldn't have learned across the street at the Standard station? What am I going to steal from them intellectual property-wise? Why would somebody have you sign the non-compete? And that is because they don't want you being poached. They don't want you going cross town. They don't want you going someplace else. Now, again, if you're going to go cross town and help a competitor, I can see somebody not wanting that. But if you're going to go cross town to get a better job, say pay more, maybe you should consider paying people more if they want to stay. And I've seen that expressed a lot of different ways, including some memes on Facebook, where they talk about how if you want people to stay, you can encourage them to stay by treating them well and, I don't know, paying them well. So I don't want to get all economic on you here, But my point simply is that I completely agree that there is a place for non-compete agreements in certain situations. In other situations, not so much. And I can tell you that in Michigan, if you go into court and you want to fight a non-compete, one ground you can fight it on is that it's not fair. It's not fair. And the question is, well, what would make it fair or not fair? Well, if I sold you a business and I said, I promise not to compete against you because I'm selling you the business with a goodwill, like let's suppose that the business is named after me, Lehto's Widgets, right? And you buy Lehto's Widgets and you're running Lehto's Widgets and you still have my name above and you're allowed to do this if I let you, my name is still above the door. And if I then open up a widget business a couple years later, and I can't use the name Lehto's because I sold it to you, but everyone knows it's me. And by the way, every Fender guitar player in the audience knows an example of this happening, right? Somebody sells their name, and then they got to go out and start another company because they don't like what's happening to their old name. So, their old product under that name. So, I understand that. But I've also seen it before where somebody gets hired to be a salesperson. You want to sell latex? Fine. Come on in. I'm going to train you. You're going to learn where we buy it from, at how much we pay for it. You're going to learn how we process it, and you'll learn who all our customers are and what they'll pay for it. I'm going to teach you all that. If I couldn't have you sign a non-compete, the second I've taught you everything, you can literally just open up a shop next door and start doing the exact same thing I'm doing. I've given you all the knowledge necessary to do that. It makes sense to me that if I'm going to teach you how to do this stuff and there's proprietary information you cannot get publicly, then that makes sense that you could ask a person to sign a non-compete. But it's got to be reasonable. So the non-compete would say you cannot sell latex in this 5-state region where we sell it for a period of 5 years after you leave employment with us. And that's a term of working here. 5-state region for 5 years. And a court would probably uphold that and say, well, you signed that when you came in and they're just protecting themselves. Now, if I said you promised never to sell latex or any other product in the United States for 20 years. Well, wait, what? I can't be a salesperson at all? Selling other stuff for 20 years anywhere in America? What? And a court would say it's not reasonable. That's not reasonable. So the question I have about non-competes in general is how fair are they? And like I said, I think they fall into 3 different categories. The executives at the companies who are given proprietary information, yeah, to have them leave and compete would be not fair. Likewise, with the sale of goodwill of a business, yes, but entry-level employees, literally people you hire off the street, and they're not learning anything that's top secret. You're not telling them what the secret formula is. You're not, actually how to make it. Fast Times at Ridgemont High. You're just bringing people in and giving them jobs, and literally the day they come in, they're doing their job. That's how quickly you can train them on that job. That's not something you need to protect with a non-compete. So I do see the notion behind regulating them. I do agree, however, that I'm not sure the Federal Trade Commission is the entity that should be regulating that. I do think that Congress might want to take a look at this. But as we all know, if Congress takes a look at this, the watered-down version is going to come out at the other end. It's going to favor some groups, not favor other groups. And that's how it goes because, bill up on Capitol Hill. So federal judge throws out U.S. ban on non-competes. A bunch of people sent this to me. This version is from NPR. Andrea Sue wrote that. Questions or comments, you may put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Say hello to my little friend.